incorporation is basically starting the basically you're starting your company. You're forming the legal entity that will that will perform the business or perform the business that you want to do. So there are a couple of options for incorporation. There's of course forming a company, an actual company with the SEC. You might register a sole proprietorship. And then I'm here to tell you the differences and the advantages for both of them. So here, incorporation. So if you're going to incorporate, which government agencies do you have to deal with? So number one is the SEC. SEC, if you're going to start a corporation, is the basically the government agency that oversees all companies, all businesses that are corporations. And your first step, if you're going the route of forming a corporation, which I think most people do, is to incorporate it with the SEC. After the SEC, you go through the BIR, the Bureau of Internal Revenue. Today, the process is very hand in hand. No? After you form the corporation, they forward your they forward your details to the Philippine Business Hub website, and then you just answer a short questionnaire, and then you're issued a digital certificate of registration. But then, of course, later on, you're going to have to get the physical copy, but that's where it starts there, no? And then after that, of course, you have to register your company with the barangay, the local business unit, the city to get a business permit, and there are a lot of permits you have to get for that. So actually, this one tends to be the longer, more complicated process compared to the first two. And then after the getting your business permits, your permits from the local government units, you of course have to get the mandatory benefits from Social Security, SSS, PhilHealth, and Pag-ibig. So that we like to call that mandatory benefits because um, it's mandatory that companies obtain these benefits for their employees. So those are the agency. That's just a quick rundown of the agencies you'll be dealing with when you're starting a business. So when is a good time to register your business? So I mean, theoretically, you could just go on and do carry out your business on your own. But then, of course, um, there are laws and complications that you have to take into account. So number one, you have to issue receipts. So especially if you're going to start making a lot of money with your startup, you will have to issue receipts because that's how the BIR tracks how much taxes you owe. And um even though on a small scale you might be able to get away with not issuing receipts, it's really no joke when the BR starts to look at you, no. I've actually dealt with a couple of clients before who, because they were issuing receipts naman, because they issued receipts improperly. The BAR still looked at them. They were still paying their taxes. They did pay their taxes, but the BAR still looked at them. They were still investigated. Thankfully, we were able to kind of help them and lessen the blow, no. But you never want to be looked at in a bad light by the BAR. They they used to have a sys- um a process where they could even shut down your business. And of course, you already went through all the hardships of setting up your corporation, your um running your business. You might already be well on your feet, which is a very hard thing to do. You don't want to be shut down because you weren't issuing receipts properly. So grants, sometimes NGOs, government agencies might give out grants. Would they rather give out a grant to say just you? the personally is a founder, or an actual business incorporated with the SEC, are registered with the government. Of course, the answer is always the latter, no? I don't know of any government agency or NGO that will just uh basically give you a grant saying, okay, well, yeah, we trust you. We trust you personally. So here's the money personally. Um, it it looks much, much more legitimate, of course, if you have a corporation or a sort of legal entity behind over the entire business. So, that's that's one that's one reason you might want to start to incorporate. You're applying as a supplier for a government or big corporations, similar to the last one, no? Except this one, for well, if you're applying for a supply as a supplier for a government or big corporations, they usually have requirements such as you have a tax clearance, you have for instance for instance if you're going to be a contractor, you have contractor certification. So things like that, you need a corporation in order to actually get those clearances and become a supplier for governments or other corporations. So they're going to look at the legitimacy of your business. And of course, a corporation is always more legitimate than someone who's just gunning it on their own. Set off your business expenses. So as corporations, businesses, there's something called, of course, we all know that we have to pay our taxes, income tax. So you can set off your income tax with business expenses, no? You file that every year during tax period. You subtract your expenses from your income tax. And this is actually a very, I mean, as an individual, maybe you might not be always interested in this, but for big corporations, this is a very big this is a very big factor when it comes to lowering your expenses. Of course, taxes, they just um the government uses them, but to a business owner, to an actual person, at the end of the day, taxes are just they're just a cut out of what you're receiving, your gross sales. And if there's any way you can reduce that cut, you want to do it. So by being incorporated, you can use your expenses, your business expenses, to set off some of the tax. And of course, you have secured a sure investor. So if you're one of the lucky ones who have a sure investor, the corporate vehicle is also the perfect way to bring them in, because corporations, they're divided by shares. That's how you track ownership, how you determine ownership. And then from these shares, you get a cut of the dividends. And when you have a corporation, it's already set in stone. You don't have to guess na, oh, this person's owed 20%. You so you don't always have to keep track of that. You just look at your general information sheet, your latest cap table, and you say, here, they have this many shares, so they own this much percent of the corporation, so they get this much. And then legally speaking, that's also how it's tracked, because if it's if kung usap-usapan lang, uh, I don't know if your investor um will be secure, saying na, how am I supposed to know that I'm always gonna get 20%, that I own 20% of the business? What's the proof, no? I mean, if, for example, if it's your certificate of title, what's the certificate of title of the corporation? So those are the share certificates, those are the records in the SEC, the GIS, and that's how you keep track of who owns how much of the corporation. So what does it cost to register as a corporation? So the time typically takes 3 to 6 months. 6 months, I would say, is very long. So maybe around 3 to 4 months. The initial process with the SEC, the BIR, that part is the really fast part. SEC usually 1 to 2 weeks. You could even there's even a system where you can do it in one day if you're a corporation. satisfies the requisites. But the that part is the fastest part. The longest part here is the LGU and the mandatory benefits. That involves a lot of legwork, dealing with the government. Oftentimes you show up to the office and then they'll ask for this document that you may not have prepared beforehand, and then you have to come back another day. And then of course they have to approve all these documents. So that's time spent just waiting for the government to approve your application. So monetary fees and taxes, of course, with every corporation registered, you have to pay some fees, especially with the first step of incorporation. And of course, mental load compliance. It's a lot of work. Imagine 3 months of your life, you just spent are just spent getting your business running. You're not even running your business yet, and there's a lot of things you have to take into account. So, what are the advantages for a corporate having a corporation? So, do you want to be rich or a king? If you want to be, so here we prepared a short table here, no? So if your company is little, it's a small company, you have small control over your company, but your financial gains are below potential, then it's a failure. You're probably not going to, unless something changes, you're probably not going to last. But if you have little control over the company, but you have a lot, your potential is being maximized, you're going to be rich. So yeah, I'm not running the day to day of my company, or I don't have the final say, but what does it matter? I have I have a big take home. So this might be your goal, typically this is the goal of some, you reach this when you you start running your company, you start running the startup, and then you meet some success, and then a big investor, or maybe it may be a company, another person comes in and says, "Hey, we want to buy you out. So we'll buy most of your company. We'll be the ones to take over from here." But you get a big payout. You might buy out all your company. You might stay on as a small part of the company. But at the end of the day, you get a big payout if you're able to build your company up and someone's able to buy it out from you. Or so there's also complete control, but you're well below potential. Here you have a lot of control of the company. You're the maybe 51%, maybe 100% of the company. You're not making as much as you could be, but you're the one who has the say over the company. You have the final say for your day to day, any big movements. You're the one who's consulted. Your decisions matter. So you might not be achieving your full financial potential, but you're the one running it. And of course, that it for many people that can be that's a nice place to be. Your company's doing well naman, and you're running the business you wanted to run. So, you might feel satisfied with your life. You might feel fulfilled, and that this is also a good place to be. Of course, we don't want to be super well below potential naman when it comes to the financial gains. We want to at least be earning, not to keep the company afloat, to have a bit of take home, to pay your employees. It could be better, but it's not super great yet. And of course, there's the exception to the rule. You have complete control to your company, and you're making a lot of money. So um this that's the best of both worlds. You're running the company you started, that you wanted to run, that you may have dreamed of from the start, and you're making the money while doing it. So um if your startup is super successful, this is the really the end goal. Although for the end goal or the ideal. But settling with selling your startup once you Once you built it up and got it running, that's also a very good goal for a lot of people. Um, Getting a startup that actually runs and runs well, even if it doesn't always even if it doesn't always meet the potential for financial gains, but at least you're the one running it and you're the one um controlling it from day to day. That can also be a good goal for you. At least you got your startup up and running and you're building it slowly, little by little. So these three here are the goals. These two are more realistic, but this one, well, if you're able to reach it, more power to you. So there. So exit strategy. This one is, of course, if you don't want to run your startup forever, what's the end goal? How do I make the most out of it? An initial public offering is when you offer your shares, shares of your company to the general public, and it's traded publicly. So typically when that happens, you lose a lot of control because shares are now being bought on the public market. You're not out there dealing with investors as an individual. The the companies are already traded publicly. Acquisition, as I mentioned earlier, if you've built up your startup, it's already running, it's already doing well, and a big investor, maybe it's another company, takes a look at it and says, we'd like to buy you out. And then, so you just have to agree on the valuation. Of course, it's a bit more complicated than that. And then typically they'll buy you out for a big amount. So you basically you're reaping the fruits of your labor, the seeds that you've sown, and then you have a big windfall from that or a long lasting business. So if you don't want to exit, you don't want to lose control, but you want to keep building your business, you want to keep making money from that, you just keep running the business. That's also perfectly fine, ano? Especially if you think na this business has still so much to there's still so many places to go. There's still so much potential. I want to keep running it. So this is also perfectly fine. So these two are the typically the you get money today or acquisitions that get money today. Initial public offering, your company you also get money, but it might not always be as instant as the acquisition. But these two, you get money. These two, you build your business, and then it's more of a constant and steady flow. So corporation versus a sole proprietorship or sole proprietor. So again, as I mentioned earlier, no, corporation you incorporate that with the SEC. Sole proprietorship, you register that with a DTI. What are the differences between a corporation and a sole proprietorship? So in a corporation, you have a perpetual existence. Before it, I think it was limited to around 50 years from incorporation, and you always had to keep renewing it. But now, by default, corporations exist forever unless you say otherwise. So it's an artificial person. It can own property. Legally speaking, all corporations have at least this right built into it. So you might be wondering, oh, well, what does that mean? I can own property, Ren. So that could be true, but then so for example, you buy some land for your office space. Your corporation can be the one who owns that land. So it doesn't have to be you personally, you who puts your name on that land. It can be the corporation to own the land and actually be the titled owner for that and all all the rights that come with it and all the liabilities also is on the corporation and not on you personally, which um might be a shield later on in case some complications arise, no, right? Succession. So When you have a corporation, what you really own there are the shares. Right, the succession here, you when you inevitably pass away, um, the succession to those shares, they go on to your heirs now. So rather than have it be super complicated as to, oh, let's divide who will how are we going to divide who owns the corporation, who gets what, can be very complicated. If you're really just looking at the shares, you could just say na, um, Air A gets 50% of my shares, Air B gets 50%. Let's say you have 100 shares, they get 50 shares each. It could be a much easier conversation than determining each and every property. So corporations can sometimes be an estate vehicle for succession there, no? Limited liability. So as I mentioned earlier, the corporation can sort of be a shield. For example, you have a contract with one of your clients. So it's the corporation signs with your client, and then let's say it doesn't go so well. Your client sues or your former client sues because maybe for breach of contract, for whatever. So rather than suing you personally, they will be suing the corporation. And let's say the corporation loses the legal suit, the civil case. Um, the court from will only award from the corporation. So yun, here can own property. Whatever you have with the corporation, let's say the award is 500,000 pesos. It's only the corporation who pays out that 500,000 pesos unless there's there are very specific cases wherein the court has found na really the contract is between you personally and the client, that you're just using the corporation to hide. Unless you can do that and the other person can prove that you abused that, be in bad faith, they can the counterparty can only ever claim from the corporation. So limited liability. Specifically speaking, you are only liable to the extent of your shares, no? So that doesn't mean that because I own 20%, owning 500,000, I have to pay 20% from that. No. So that's really only at the end when it's time to liquidate or close down the corporation, how much is being paid, or if there's piercing the corporate veil, um, the shareholders personally have to pay out the aggrieved party. That's when that's when the shareholders have to actually take out money. But unless they can prove that, which is very, very rare and very, very difficult, it's only the corporation who has to pay. So this is a very useful tool for protecting the shareholders. So free transfer of shares. Of course, there's some taxes, but for example, you want to tweak who owns what. The founders want to tweak like who owns how much of the corporation. Let's see, at the start, founder ABC, let's say they all have 30 30 30 33 33 33, and then later on founder C is kind of wants to back out. He's been less active with the running the corporation. It didn't turn out to be his cup of tea. So rather than being stuck with the corporation with something he doesn't like, and of course, founder A and B who do want to run the corporation, um, medyo lugi din sila because we started this 30, we're all 33%, tapos founder C still has the same ownership. He's not even interested in running the corporation anymore. So what you can do there is you can just buy out those shares so that founder C maybe 10% na lang, and then divided with The other 23% divide between A and B. So, so no hard feelings. At least you can do it on a professional, completely business level, that you transfer the percentage of ownership from one person to another. So free transfer of shares. And then can incentivize investors, founders, and employees. So because you have ownership of the corporation, you know, uh, you're in, you own 30% of the corporation. You want personally to see that the corporation does well, because whatever you get at the end of the day, whether it's a dividend, so a cash dividend released by the corporation, or someone acquires a corporation, that's determined by how much you own the corporation. So if you own 30%, and let's say the big investor says, I'm going to buy out your corporation for, say, 100 million pesos. So you get 30% of that, 30 million pesos. So you're incentivized in the way na, if I'm able to grow and make the company succeed, or maybe if I'm very successful, instead of 100 million at the end, it could be 200 million. So you get 60 M. So these people are very incentivized to see that the corporation succeeds. So for employees, Ren, what some companies do is that for loyal employees, there's a stock program na, because of we want to reward your loyalty. You've been with us for 3 years from the start of the corporation to the company to what it is today. Now that before we were running on sticks and stones, and then today we're a big corporate body, we're a big company. So we want to give you some stocks for that. So maybe you award, like, I don't know, maybe 5%, 10%, depends on how the kind of role the employee has, how integral they were to building that up. So um, some companies like to reward their loyal employees who have been with them from the start with some ownership in the company, which is a perfectly fine thing to do. So the cons naman, difficult to register. Again, no, kanina I listed down all the agencies. Um, Dealing with all those agencies, those government agencies, it's sometimes it's no joke. You it might seem like, oh, I just have to submit these documents naman. I just have to do it one time. But I think you should never underestimate how much the government would like to keep you parang just running to and from. So yeah, on paper, maybe online, you looked it up and said na, oh, I only need document ABC. The person at the desk, they say, oh, nasan yung document D, for example, where's the contract of lease? So you don't have it with you right now. So you come back another day, and then very frustrating and very common. You come back another day, you have your document D, and then they'll only ask for document E. So you have to go home, come back. Very difficult, it's a very long and tiring process to register. More compliance requirements. So, of course, as a corporation, as a company, the government agencies, now that something actually exists, the government agencies, SEC.
Attorney, excuse me po. I think you're inaudible po. You're muted. Attorney. Attorney, please. Excuse me po, attorney. Attorney, you're inaudible po. We cannot hear you po, attorney.
Hello.
That is better po. Opo.
Sorry, sorry. Ah, um, Sorry, I'm not sure which part did it cut off. Can you let me know lang? So I discussed incorporation. That one was okay naman.
Yeah, you may continue po, attorney.
Okay, okay, okay. So ayan. Um, Comparing the sole proprietorship to a corporation, the um sole proprietorship is much, much simpler than a corporation. So simpler to register, simpler to comply with. You just submit some documents to the DTI and it's done. You have a sole proprietorship. Might be better for a small business run. But the cons are the personal liability. So I made a big deal about the limited liability earlier in case something goes wrong now at the end. They only come after the company and the company assets, what's named under the company. Under a sole proprietorship, there's no such limited liability. Um, Basically, sole proprietorship, you have a trade name and that's it. It's still you who owns everything. It's still you who runs everything. So if something happens and your ex-client sues you or anything sues the sole proprietorship, they're not suing a different legal entity. They're not suing an artificial person. They're suing you personally. So if um, if it if it goes really bad for you, even your assets that are not included in the sole proprietorship, not for the business, will they'll come after that friend. You can incentivize investors, founders, employees because it's just you naman. So usually the incentivization comes from the ownership of shares. How much of the company do I own? And because it's a sole proprietorship, it's you personally. So how do how can you tell a founder, oh, um, invest 30% in my sole proprietorship. We have a lot of potential. It's a sole proprietorship, so how can they invest 30% in you yourself personally? You can't, you know, sell you can't give someone 30% of ownership of you as a person. So and employees parang it, you again same idea parang how can they own any of the business when there's nothing to own. It's just you run using your assets to run the business. You're the one who's just running it like that. There's nothing to keep track of to see na this is the corporation the my business is divided into shares and people can own this much. So there's no and you look more small time. That that might I mean that's not a strictly but when you're dealing with big companies with other people, then it really is more impressive to say that, oh, I own this company or I run this company or I run a sole proprietorship. Parang, I guess yung sole proprietorship people have the impression na right pag sari-sari store lang or smaller business or a community business, it doesn't look very impressive. So here, just a quick summary of what we talked about earlier. Tax for the corporation. it starts at 20%, ends at 25%. So even if your corporation is small time, 20% na siya. For sole proprietorship, could be as little as zero if if you're a very small sole proprietorship, but as high as 35%. Corporation liable for debts, what I mentioned earlier, limited liability, something bad that happens to the corporation, and then it's made liable. It's only the corporate assets that are decided against here. So sole proprietorship, owners liable for debts. Any debts a sole proprietorship incurs, you have to pay for it personally if that's what it takes. Easier to attract capital since it's more since you can sell your shares, no, actually sell ownership in the corporation. It's easier to sell to investors because they can have something in writing. It's very official that they own 20%. So it's easy to attract capital. Hard to attract capital because you're asking investors to invest in you personally. They don't have any particular ownership of the company, or there's no company. They have no particular ownership of the business in this case. More complex paperwork. I mean, sa incorporation pa lang, the corporation, the entire process is more complex. So proprietorship, very simple. You just submit some requirements to the DTI and you registered. That's that. So I would also suggest that corporations are better for startups. If you're going to make you if you have any future plans or any big plans in your future, you wanna attract investors, you want to get big clients, you want to hire a lot of people, always go with a corporation if you have big plans in the future. But if small business lang, I just I'm just doing this as for my side job. I'm just I'm satisfied na it's a small community thing or a small business. You might settle with the sole proprietorship na lang. It's okay. So when it comes to what governs corporations and uh how they're run, there's the hierarchy here. So there's the law, the revised corporation code, and other laws. These, of course, are the king. There's the articles of incorporation. When you incorporate, this is the one you make. Basically, articles of incorporation, the bylaws. These are kind of the rules that you guys agree to follow in the corporation. And then there's a shareholders agreement. So this is just an agreement between the shareholders that, okay, it's not in the articles of incorporation, but we agree that among shareholders, this is how we're going to conduct our relationship. This is how we're going to be with the business, no? This is how we're going to carry out our business and our dealings with one another. So, yun, the law is always first, and then it looks at the articles and bylaws, and then the shareholders agreement, if any. So articles of incorporation. I'll also talk about here, the actual the actual process of incorporation. So all incorporation now is done through the SEC Spark online platform. Before you could do it on Business Hub, there was a maybe you could do it even in person, but now it's all done through eSpark. And then as another complication to that is that all incorporators, meaning directors, treasurer, anyone who will own shares in the corporation, they all need a verified eSpark account. So making an eSpark account and verifying it is a simple um, process naman. It's not too difficult, but you just have to know that everyone needs that because you have to submit the details of the account to the SEC eSpark. You So anyone can make an eSpark account. To have it verified, you just need two IDs and a webcam. So you submit your IDs online, and then you just do a short webcam verification to see that it's actually you. And then you'll have an eSpark account. And that eSpark account will be used for the incorporation and to even sign the documents later. So in the terms of the articles of incorporation, they're automatically generated by the SEC. The terms are very, ano naman, they're very, they're very simple naman. It's basically the bare bones terms. What you have control over here, of course, are the details, the corporate purpose, but all the boilerplate or typical uh, provisions, the SEC determines that. So all details, you have to finalize them already when you're starting the corporation. So office address, authorized capital stock, the kinds of stock, how you're dividing the stock. These are very important things to have finalized before you um push through. Because if you i- in the event you are successful in incorporating, and then later on you say, I pero our office address, parang we're not going to push through our initial plan. We're going to find a different office. You have to get that amended with the SEC, which is actually a more complicated process um than just having it right from the start. No, uh, you have to go through the SEC amend. It might take several months before it but whereas before you can have it amended. Whereas if you just had we just finalized it before you guys even started, it's all there now. Also increasing the capital stock, that's also a that's also another complication with the SEC having it amended. I think if I'm not mistaken, at least 20% of your stock today have to be subscribed for you to further increase it. So there are many rules like that. There are many rules like that you have to take into account when you're going to amend something. Whereas when you were starting out, today there's no ano eh. If you have if you want to incorporate with 1 million shares na 1 peso each. If you want to say na, okay, that's my authorized capital stock, I'll discuss what the difference between authorized and subscribed capital stock later on. But if you want to subscribe only one share of that, one out of 1 million, today the SEC doesn't they don't say no, there's a minimum na 20%. It will be perfectly fine. Whereas later on when you're amending it, they might start to look and say, why are you increasing it? Why are you increasing your authorized capital stock if you didn't ano rin naman, you don't even have 20%? There are many questions, there's more input, there's more complications than when you were just incorporating. So after some aside from this is also the corporate name, no? The SEC, eSpark already checks that for you to see if the name is available, if it's appropriate. So after submission, you only get one chance to revise any of this, or else you have to start over again. So basically, you submit the details, and then um, before you lock it in, you have one chance lang to change any of this. So, or else you start again. Um, it's not so bad to start over again in case na you miss your window. After going through this process, you only have 2 weeks or a week, but you only have a short amount of time. A week, sorry, not 2 weeks. You only have a short amount of time before you can before you have to submit everything. If not, then you have to fill it out all over again. There's no payment yet at this point, no. It's only when you lock it in that you have to pay. But um it's just it's just a time consuming process. You just typing everything out. You're just filling up forms. It's a bit of a hassle lang. So costs are largely determined by the authorized capital stock plus other fees. If I'm not mistaken, this is 1% of the authorized capital stock, no? So for example, a if you have authorized capital stock worth say 1,000 pesos, you're and there's a minimum here. I think the minimum was 1,000 for the costs here. Authorized capital stock of let's say 100,000 pesos, then um the fee here will be 1,000 pesos plus other fees. So there's the bylaws, that's 1,000. Legal fees, I think that's like 30 pesos. So it's really the main factor here is the authorized capital stock. So if you have something like 30M of authorized capital stock, then 1% of that plus other fees. So, your initial costs are determined by how much authorized capital stock you have. So the difference between a corporate name or a trade name is the corporate name is what your legal name is. Trade name is like a nickname. So here, for example, very common and very famous example here. In the Philippines, there's no McDonald's Corporation. Their legal name is Golden Arches Development Corp. But their trade name is McDonald's. We all know McDonald's. So that's the difference between a corporate name and trade name. You also go through that with the articles of incorporation. Of course, you don't have to have a trade name. You can, for example, if um, Golden Arches is also going to be the name of your net restaurant, then no need for a trade name. Or if you want to incorporate McDonald's Development Corp or McDonald's Corporation as your no need for no need to have these separate. But these just for clarity in case you guys come across it. This is the difference. It's really up to you whether you want to have a trade name that's completely different from your corporate name or not. Um, but sometimes kasi when you're the SEC, when it's looking at the corporate name, no, sometimes your corporate name is taken. So what do you do? Well, your corporate name might be taken or it might not be acceptable. But if you wanted to operate under that, you might still be able to operate it as a trade name. So if for example, I want my corporation to be and trade name to be ABC Corp, but ABC Corp is taken. So ABC as a corporate name is taken. So instead I'll incorporate as XYZ Corp with a trade name ABC. That one might still be acceptable or available now. So that's basically the difference there. So this one for structuring, it's a bit maybe later on, no? Because as startups, you don't typically have structuring is a question you ask for when you're grown na. So sometimes there's a big parent company that will be the holding company, and then different subsidiaries to handle the different businesses of the company. So for example, I used to work in Miescor, the construction arm of Meralco. That would be, for example, subsidiary one. Meralco is the parent company, and then maybe they have a different company. Let's say they have company that provide connectivity services. In for Meralco, that was Radius Corporation. So Radius Corporation is subsidiary two. So Meralco is a holding company, Miascor subsidiary one, Radius a subsidiary two, and then these subsidiaries might even have their own subsidiaries. So in my example, Miescor is the baby of Meralco, but Miescor itself has its own baby, Miester Logistics company incorporated. So MLI for short. They do the manpower services. So Meralco owns Miescor, the construction company, but Miescor has its own manpower service subsidiary under it. So that's basically what this graph is depicting, no? Later on, if you want to branch out into other fields of business, you might want to um consider this type of um this type of this type of structure or division. So you might start with your startup now. It grows. Let's say it's a restaurant. You want to open up another restaurant, which is a different company. So will they be two different companies, or how will the ownership be divided among that? So what you can do is you can open the other company and then open a holdings company that will own both your shares in subsidiary one and subsidiary two. So let's say the holding company owns 51% of subsidiary one, subsidiary two. It's the big parent, and then um, that's how you distribute or divide who owns what, no, within the holdings company na. So it's a bit complicated to discuss here. And maybe it's a bit advanced, but this can be something you can explore in the future. So there's also the Foreign Investments Act. So depending on whether, of course, a lot of startups, a lot of people might ask, no, oh, I'm going to get foreign investments into my startup. Uh, can they do that? How much can they own before it becomes illegal? Or what are the rules when it comes to this? So we look at the Foreign Investment Act. Typically speaking, I didn't include it here, sorry, pero the division could up to 60/40, as in 60% Filipino, 40% foreign owned. Assuming it's not part of this list, um, assuming it's not part of this list, that division is okay. There's no minimum na that you have to meet. But it's 60/40 in favor of the Filipino. There's no you don't have to be too concerned about how much money is invested, or any requirements. So 60/40, of course, I'm talking about the shareholdings. However, if you want to if the foreigner wants to go beyond 40%, so up to 100%, the minimum capitalization for that is 200,000 pesos. But if you have 200,000 pesos lying around, then by all means, go ahead and 100% foreign owned. So ayun, that's what you have to take into account lang. 60/40, and anything beyond that, then your authorized capital stock and subscribed capital must actually be 200,000 pesos. So of course, that's a general rule. There are exceptions to that rule that are embodied in the foreign investment negative list. In this case, this rule doesn't apply. So um, in those cases, it might be strictly na always 60/40, no matter what, walang 200,000. So this option might not be available. And for some extreme cases, absolutely no foreign investments are allowed. So if ever this is a short list. Now, of course, the foreign negative list is a bit longer than this, but just for a quick note, ito yun, mass media, pharmacy, X-ray technology, criminology, forestry, law, retail, trade. This one might be the one that's relevant to start to you founders. Cooperatives, private security agencies, small scale mining, utilization of marine resources. So um, if your business is similar to any of this, or um, you might want to look in deeper into the rules to see ano. Retail trade with paid up capital. Retail trade in this example means retail trade in this example means selling to clients, B2C, business to clients, so selling to the general public. So you need at least 25 million capital for you to start retail trade if you have any foreign owners. So the difference between I talked a lot about authorized capital stock, subscribed capital stock, paid up capital stock. So if you're going to look at this illustration of milk tea, authorized capital stock is how much um how much investments the company can take. So that's the milk tea glass. Subscribed is the milk tea itself. So um, I can only fill it up to as high as the glass, of course. So I can only take investments as much as I am authorized to do so by the capital stock. Paid up capital stock is a stock that people have actually subscribed and paid for now. So they've actually paid for it and a certificate has been issued. So ayun, if you're ever confused, it's usually these two that you're confusing. Paid up, pretty straightforward. It's paid for. Um, Authorized is how much your company can take in. Subscribed is how much has been invested in. So authorized is the cup, the milk tea cup. Subscribed is the milk tea itself. So dilution, in for example, if you own 10% of this milk tea here, of the stock here, and then they increase the capital stock, so you pour your milk tea in a bigger glass. How much is your 10% here? Of course, here it's 10%. Here, where it double the authorized capital stock doubled and more milk tea was poured into, more investors came in, your investment might have been diluted down to 5% or down to ano. So if this famous movie, the Social Network, if with where Mark Zuckerberg was arguing with one of his co-founders, uh that's the entire point there, no. That's the entire point that they were arguing. So here, that person might have owned 50% of the company, and then when they poured it, they made the shares bigger and they diluted the shares. It might have been reduced down to 10%. So when it comes out to paying the dividends or out coming to buy out the company, he gets a smaller cut of the pie. That's why very this a very this was a very pivotal scene in that movie, where very argumentative. So what usually happens when you do that is the current shareholders have a preemptive right when you're increasing the stocks, no, na okay, we're doubling the stocks and we're introducing more investors. So when you're introducing investors, say everyone was 100, if you have 100 shares, I own 30, 50-50, you add someone who gets 50, who has 50 shares then, whereas before you owned 50-50, um the in the new in the new in the new in the new shareholding, you will have less na preemptive rights. They're given It's basically a right na okay, we're going to sell the shares, but so that you don't get diluted, do you want to say, do we sell it to you na lang, or do you want to top up your shares to the so that you maintain your percentage. So you could exercise that right. You say na, no, I want to say 20% here, I'll buy your shares na lang. Or you could say na, no, it's okay. I don't want to ano. So in my example, 50-50 and then they're adding 50. Each of the founders both have the right na, um, no, don't share it the two people both have the right. And don't sell it to this new person na lang. Instead of, if you want to raise capital for 50 more shares, we'll be the ones to buy that na lang. So they maintain at 50-50. And these rights are, of course, exercised independently of each shareholder. So if in my example, shareholder A wants to exercise the right to top it up, so he'll buy 50% of the incoming, and then shareholder B doesn't, then that's all right. So he keeps it at he keep the shareholder A stays at 50%, shareholder B gets diluted to a lower percentage, and then the new shareholder C, um, they get to buy whatever was left from shareholder A. So this is also in proportion. So if you're, for example, 50%, you can only buy 50% of the shares. You can't go beyond that to increase what you used to have. It's just to maintain your percentage. So when you're incorporating, you're in the articles of incorporation, you have a corporate purpose, no? Basically laying down what exactly you're going to do. So the broader the better. Because if your corporate purpose is broad, then your corporation can do more things. This is the lays down exactly what your business is going to be. So if you're going to I'll illustrate it better later. But if you go beyond what is written in the corporate purpose, then you're ultra virus, and then the SEC might penalize you for that or tell you to stop doing what you're doing. So yun, determines exactly what your corporation can do and what kind of businesses it can pursue. So for example, I incorporate a restaurant, but then I want to branch out and say I also want to um have it be a delivery service. If I did not include that in the corporate purpose, then I won't be able to do it. I have to either amend my corporate purpose um or incorporate a different company. So better to see better to plan ahead and think in advance what you want to do, how you want to expand so that you can include this na rin. Uh, Typically what I like to do is that if there's a big company, for example, a restaurant, I don't know what exactly is a good corporate purpose, how is it nicely worded to be broad enough that I can expand reasonably, but that says exactly what I want. What I sometimes do is that I Google it online and look for the articles of incorporation of a publicly traded company. So a restaurant, for example, I look at uh, corporate purpose for a restaurant. So let's say I find Max Fried Chicken, what their corporate purpose is. So if it works for Max Fried Chicken, it will probably work for you as well. So you don't have to super copy it, but it will be a useful guide to see na, oh nga, no, they thought of this. I didn't think of it. Let's put it in. So for businesses like that, there are people who have pioneered or trailblazed it long before you have. So it's best to learn from what they have done. So types of shares could be common or preferred. This also has to be determined as the articles of incorporation. So common shares, they're able to participate with the company. That's basically it. They're able to participate in the company. They're able to vote who the directors are. But they get dividends, they get payouts, they get acquired or closed, liquidated. At the regular they're treated regularly for that. Preferred shares naman, they don't participate, they don't vote, they don't do basically they just put in money and then they just say, okay, kayo na bahala. You guys run the corporation. I'm just going to I paid my money and that's it. So they don't participate. but they are preferred to dividends and as a closure. So when it's time to release a dividend or pay out, or when it's time to close the company, these shares get paid before the common shares. That's the basic difference there. So these are just some other features of shares, cumulative or non-cumulative. Are they are are all the shares counted together? For example, cumulative um common, cumulative preferred, redeemable. Can you sell the shares back to the company? Participating, non-participating. Does it vote with the company? Does it actually help run the company? So once you do the taxes, SEC zero, you do the taxes with the BIR. Your application is submitted to the PH Business Hub platform. So that's another website that you can register your certificate of registration there once you ano. I think you also use the same eSpark details for this, no? So you obtain a certificate of registration. It tells you what kind of taxes you have to pay. You answer a tax type questionnaire. It's just basically a one-page question and answer, or you just check some boxes where to see what kind of taxes are due. So most relevant question is typically is what is your projected gross per year? It's relevant because if your projected is beyond 3 million, then that's a cutoff for non-VAT. So if you make 3,000,001 pesos per year gross sales, you have to be VAT registered. So you should register and obtain an authority to print with your local office within 30 days of incorporation. So if not, you get some penalties. This one's very fast lang naman, no? So just something to note. SSS Health Pag-ibig, best to start within 30 days of incorporation. You typically just need the corporate documents. I you don't really they don't really ask for your BIR, no. So you just submit your certificate of incorporation, your articles if they require it, and then some other documents that they may ask, some forms that are available online, and IDs. So any longer, and the SSS may require to submit a general information sheet, which would typically you would not have to file until next year. So you take too long here, they'll ask you for something else. This is not super hard to ano naman, but um, if you don't have to do it yet, um, and then now they're asking for it, then it's just adding another step, no? So they may also require that you have at least one employee before applying. A lot of startups and companies that have handled new companies, they want to register now because they want it out of the way. But then at the offices themselves, the SSS offices themselves, they'll ask, oh, how many employees do you have? They'll say, ay, wala pa po. They'll say, come back when you have employees. So very, very, that's something that you have to take into account. And then pag-ibig, usually they'll just wait. They'll just use your SSS details, your SSS form to 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 register on their in their system. So SSS has to be completed before pag-ibig. But if you're done with SSS, pag-ibig is not difficult. This complication usually happens lang with the SSS. And PhilHealth is independent of the two. They just go to PhilHealth and register your company. But still important for you to get that. So just to get this done as soon as you can so that you don't have to get a general information sheet, which you may not have had to do if you had done it on time. Of course, there are also penalties for late registration, but lalo na, for example, you didn't have one employee when starting, so you only registered 6 months after. They might charge you late penalties for that, but typically they don't really exceed even 4 digits. So um, yun, you still want to register on time, but the penalties are not super terrible. So some contract principles. Of course, every time make a contract or you have a deal with someone, you want it in writing because if it's just a verbal contract or usap-usapan lang, when you guys fight later on, they're going to say, um, so who's if you take it to court, if it even gets to that point, they're going to say, oh, whose word are we going to take? Person A or person B? And of course, at that point, you guys are already arguing with each other. Even before court, you're arguing with each other. You're always going, each party is always going to say or always going to interpret things to their favor. Um, so how do we avoid the confusion in that case? You just have it written down as a contract. So you have it written down as a contract. You what the parties agree upon. It's already in writing, so there's no point in arguing. If anything, we'll just argue about um how to interpret what's written down. But we're not going to say, "Oh, kala ko ba walang interest to?" And it's like, no, of course there's interest. You don't have to say that because you say, "Oh, ito here. This is the interest provision. Clearly there's interest." And you say, "Ayaw nga, no. Okay, fine." So yun, things like that. You don't have to argue it later on. So notarization, do you have to notarize every contract? No. Most contracts you don't have to notarize them for them to be binding and valid. But they are helpful for evidence because when it comes later on, when it goes to court and they say, uh, when you have it notarized, you basically you're saying that I'm entering into this in my free will. I understand everything that's written in this contract. Um, Later on, there's no saying na no, no, they only there's I was only coerced into entering into this contract or and of course when you notarize it, it gets recorded as a public document or you can there's no saying na hindi, that's not the actual contract we signed. It's something else. So it's this version two. And you'll say, but no, look at the what's notarized. Let's bring it up in the public record. This is what was notarized. So ito yung controlling. Your notarization eliminates a lot of questions like that. So investments, there of course as a startup, as founders, you want to ideally you will have someone who invests in your company. So how would the investment how would your investment what's the entire process of investment? So we can also look at the vesting process. So it can either be time-based, milestone-based, acceleration. All this more for employees, no? When you're getting in an investor, of course, they invest in your company, so and then they expect to get the shares agad. But for employees, it can be time-based, milestone-based, acceleration-based. So um time-based, say after 3 years, we'll give you the shares, or even the founders, after 3 years, we'll give you the shares after working with our working to help us start our startup. Milestone based, after we grow the company to a certain size, certain amount, you'll get your shares. Or acceleration if, for example, this one is also a bit of milestone based. So if you're able to do these, if you're able to perform these tasks, even though it's not a milestone, like you're able to secure a new investor, we'll give you your shares faster. So board of directors, they're the ones who decide to release dividends, buy property, and enter into agreements with other companies. So they basically this one basically means they run the company. This one, what kind of assets come into the company, and this one, when to pay out the investors. So exit mechanisms. When does a shareholder split from the company, or how do they split? So right of first refusal. Before asking for any of that, usually what you do is that when an investor or a shareholder wants to leave the company, they have to offer their shares first to the other shareholders if there's a right of first refusal. So investor ABC, C wants to leave. Before he sells his shares to other people, he has to first offer it to A and B. And then if they say no, then go on sell it to a third party. Tag along right. Um, for instance, if ABC again, C wants to leave. If C wants to go and sell his shares, B, if he has a tag along right, B has the right to say na, sige, I'll sell my shares when. So combined with the right of first refusal, he might also have to offer to A. So if A wants to exercise his right, he has to also buy the rights from B. And then when C is selling to third party, B is also selling it to them rent. The dividend policy, either you release a cash dividend. This dividends are how the company gives back to the shareholders. So if they have unrestricted, unretained earnings, meaning um, money they've earned that they're not investing or using to grow the company, and are not promised to someone else or to be invested elsewhere. So basically, just money that they've really earned and have no plans for. They can release it to the shareholders as a cash dividend. So they release share in proportion to their shares. So if it's 50-50 and you release a cash dividend, each shareholder gets 50% of the total unrestricted, unretained earnings. So 50% of your earnings. Or reinvestment, you could use it to give a stock option. So here, rather than um release cash, we're giving you more stock to grow your to have more ownership in the company. So for board of directors, no, there for voting requirements in a company, typically for board of directors, you just need a quorum, majority of a quorum. So quorum is 50% plus one, and then 50% plus one and majority of that. So if you have five directors, then 50% plus one, 3.5, round that down to three. You need three to start quorum. Majority of quorum is two. So earlier, here, typically typically these would be that's what you do. Majority of quorum. So you need two people in that scenario to agree to buy property agreements or enter into agreements. So here, there's special cases lang where that's not the case. So once increasing capital stock, amending the articles, investing in a substantially different business, or removing a director, you need 2/3. And then amendment of bylaws, you need 1/2 plus one. So when for corporations, you need three there are three corporate officers: the president, secretary, and treasurer. So the president cannot be the treasurer and they cannot be the secretary. The treasurer can be the secretary naman. Foreigner can be the president so long as he's a resident of the Philippines. Another addition to this is that the corporate secretary also has to be the all of these people also have to be residents of the Philippines. Treasurer has to be a resident. Um, they can also be they can also be a foreigner, but they have to be a resident of the Philippines. Secretary has to be a resident of the Philippines as well. So here are just some quick questions. What are the responsibilities of each when you're incorporating? What are the responsibilities of each founder? Whenever you're incorporating a startup, it's best to have this mapped out beforehand, maybe even in a shareholders agreement. Typically, we advise and we do for our clients, we prepare shareholders agreement so each founder knows what they have to get their to be a part of the startup. So do all founders get their shares immediately? Um, For some founders, they're only there to invest the capital. So typically they get their shares immediately. Some founders are there to perform a certain business, certain task for the company. Let's say I'm gonna do marketing, ano. So I'm going to do marketing for the company. Do I get my shares immediately or do I get it after working for a couple of years in the company before I'm awarded my shares? So what happens if a founder leaves? These are all questions that typically should be answered beforehand and ideally answered in a shareholders agreement. So what happens if a founder leaves? Um, do they get is there a right of first refusal? Uh, how are they able to exit? These are questions that should be answered there. What if happens if a founder does not contribute? So for example, one of the founders, again, my example, they're supposed to do marketing for the company, but they're not able to do it. So what happens? How do we kick them out or how do we call them to attention? You want to answer that in a shareholders agreement. It should be done in the first profits. Yun, how do we expand? How do we grow? Do we release, pay it back to the, capital founders? Do we pay back the investors kaagad? There are many ways to answer this question. Depends from person to person, from start to startup. All founders are required to go full time. Some founders might just be investing money. Some might be doing it as a side job. What's the kind of commitment you want from your founders here? Here, how do founders plan to make money? How do they plan to start? How to make money from the startup? How do they plan to get paid by the company? And what should be done with the profit of the company? So, yun. I mean, pretty straightforward. So these questions, ideally, you answer them before um you start your company because when you're answering them in the middle of running the company, it can get very messy. When founders fight, um, usually usually there's a lot of fallout from that, and it better to have it all planned out and decided beforehand what should be done so that no hard feelings later on. So these are some documents lang that you might want to finalize before entering into a startup of or have on ready, especially when you have an investor, no? So a term um when you're investing when someone's investing in your company, usually they'll ask for a term sheet. So what is a term sheet exactly? It's not yet them investing into the company, but it's you setting down what are the terms of coming into the company. So it's a preparatory document, usually non-binding. Usually the binding part here is only the confidentiality or non-compete parts. So sets down important notes and points for the corporation and typically includes details such as company information, investor information, amount and equity of the offering, payment details, undertakings, warranties, timetables, investor rights, etc. So basically, anything an investor wants answered beforehand is usually as answered in the term sheet. So just it's to inform them what exactly they're coming into, how much they're saying how much you're offering to them, how you'd like to be paid, undertakings such as the company has paid all their taxes, for example, and is properly registered, warranty saying um for instance we have these kinds of certifications, we're allowed to operate. Basically you're telling the investor what they're coming into. So that's what the term sheet is. So investment instruments, these are the ways that you can enter into invest into the companies. There's a subscription agreement. That's the typical, most common, most straightforward, most straightforward type of contract. Convertible note. That's a loan that might later on mature into equity or ownership in the company, and a safe note, which is the it's kind of a mix between the two. The person giving the safe note puts in some capital. They don't get equity yet, but later on when a price round or a price offering is when you offer to sell shares later on, the safe note matures and then they get to buy shares during your price round or offering at a discounted rate. So shares in exchange for cash. That's basically what a subscription agreement is. You're just straight up buying the shares. So um not too complicated there. Of course, you just have to determine how much you're selling each share for, and for how much you're selling each share for, how much shares you're selling. So how you evaluate your shares. So who shoulders capital gains tax? Who shoulders documentary stamp tax? Capital gains tax is typically that's when the difference between the actual value of the share and the how much you sold it for. So for example, actual value of the share is 50 pesos per share, but you're selling it at a discounted rate of 40 pesos, or you're selling it, I don't know, even higher at like 60 pesos. The difference between between the actual value and the actual value of the share and the sale price, that's capital gains tax. So you might want to answer who will pay for this tax. Will it be the buyer? Will it be the seller? Documentary stamp tax. In every every subscription agreement, there's documentary stamp tax. Or even when you're um, subscribing to new shares, there's a documentary stamp tax. Um, how much, how who will shoulder that? Documentary stamp tax is usually 1% of the total sale, no, total value of the shares. So if you're selling 5 million shares, 5 million pesos worth of shares, 1% of that documentary stamp tax. Who processes the transfer? Typically, it's the seller because subscription agreement, you're subscribing to new shares. Usually, it's the company that will be the one to bring in that because they're also the ones earning from the uh from the from the sale. But and they're usually the ones who have the mechanism to do it because issuing the share certificate, um, recording it in the books, updating the GIS. It's obviously the company that does that. And what happens to the transfers ongoing? So, um, these things these are things you might want to ask uh, when you have a subscription agreement. So, convertible note, debts that can transform into equity. So rather than just buying up the shares straight up, you might extend the loan to the company, and later on, if the company will still pay the loan at whatever you agreed upon. But in case, for example, they default or they can't pay later on, then the shares could be converted into the debt can be converted into equity or shares in the company. So as with any loan or any debt instrument, how much is the interest rate? When is the maturity date? And what does it convert into? So interest rate, how much rates you're paying, when is the maturity, when are the when are the payments due, and if they can't pay on X date, when um when they can't pay on X date, how much shares are awarded in that case? What does it convert to? Yeah, that's how much shares is awarded. So this one is how much, when, and what percentage does it convert into? Safe note. So SAFE, the is short for Simple Agreement for Future Equity Warranty. So in this case, as an investor comes in, they pay money to the pay money to the pay money to the startup, and then they don't get they're not expected to get paid back right away. They're not expected to get shares right away. But later on, when the startup or the company offers to sell shares to other people, these people, the one who issued the safe note, they get basically they get priority there at a discount. So valuation cap, how much exactly can the safe note, or how much can the safe note be redeemed for, or when does the when a company gets to a certain point, when does the safe note get redeemed and converted into equity? And what is the discount rate? So, they're not getting money today. They're not getting the shares today. They're not getting any money. They have to get something, So the discount rate is usually is usually the yun yung selling point ng safe note for an investor. So here, equity. These are the differences between the three. Subscription agreement, you get equity right away. Convertible note, it's a debt that turns to equity later on. Safe note is a warranty that, okay, today I'm not getting wala akong utang, wala akong equity. But there's a warranty that later on when you reach this when you grow your company to this size and the offer shares to these two other people, I'm the first one in. I'm the one who gets the discounted rate. So here requires an agreement evaluation. Also requires an agreement evaluation. Here wala pa. You just have to agree on what will set off the safe note. But um it might not be um it might not be my 50,000 safe note investment, 50,000 peso safe note investment gets me 50,000 shares. It might be something else. That's determined at a future date. But say what you have here is I have 50,000 that I'm going to convert into a discounted rate for shares. So neutral here. Subscription agreement, it's cash for shares. So both parties are on relatively even footing. Convertible note, investor friendly because, well, I mean, it's a debt that turns into equity. So, um, I give you money, it's a loan, and then, the company either does well, pays me back, so um, I get some profits from that, or the company is not able to pay me back, and then I own shares in the company. So, could be a win-win for the investor here. Safe note, founder friendly. I don't have to give you any equity yet. I don't have to give you shares yet. I have complete control of my company. I don't have to pay you back yet. Um, what it become it The only time this one matures for me is later on when I'm able to offer a round of selling shares to other people. That's when um that's when I have to sell to you. So that's when I have to let go of equity. But you largely have the control here of when that happens. So matures during a price round at a discounted rate. So that's what it means. So data privacy. Typically data privacy. Not all startups um will have it as a big deal, no. And usually, the appointing a data privacy officer comes in later on lang when you're a big company. Although it's still important to set down data privacy terms for your company. So when we're talking about data privacy, what are we talking about? So we're talking about personal information. So personal information is generally any information that you can use to identify an individual. So for example, your name, obviously, personal information. So me, Attorney Luigi Ocampo, you can identify me through my name. Um, Even for example, your cell phone number could be a personal information rin because it's all only one person has that. I know, even if it's not just one person, it's you can reasonably reasonably deduce who a person is with their cell phone number. Na okay, one person has a cell phone number. It can only be at Luigi Ocampo. Things like height, weight, or could also be used as a personal information. Address, of course, personal information. These are all that's personal information is information that you can use to identify someone with. Sensitive personal information, on the other hand, is a subset of personal information laid down in the law. So things like race, ethnic origin, marital status, age, color, religious, philosophical, or political affiliations, health, education, genetic or sex life, or any proceedings where government proceedings, um, um, information issued by government agencies, such as, for example, your driver's license number, social security number, um, licenses, etc. And then anything Congress or the president says it's personal information and should be kept classified. So that's the two kinds of personal information. When we're talking about data privacy, we're talking about the privacy of personal information and sensitive personal information. So when talking about data privacy, there are three parties we have to talk about. There's the data subject. This is the person who owns the personal information, usually your user, your client. Personal information controller, person who controls the personal information. So maybe you're also the one who collects the personal information, the one who keeps the records. This is usually you as the platform or the founder, the startup. You collect information from your clients, you store them, and personal information processor, person who processes the personal information, usually a third party. So have some, if you have like maybe a program or something to or where you submit the personal information for whatever purpose, that's the personal information processor. So when talking about data privacy, you have to set out in a statement, data privacy statement, you have to set out what kind of personal information you will be collecting from your data subjects. So you have to already specify what exactly you'll be asking. So for instance, we will be asking you for your name, address, age. Yun. So you specify that you'll be collecting that, what exactly the information you'll be used for. So let's say we'll be collecting your name, address, age, because we will be using this information to disseminate a prize that you want, or a promo or promotional prize that you want with our company. That's what will be used on. It will be used for, and who will have access to it. So only for example, our employees will have access to it on a need-to-need basis, and then the prize provider. Let's say the prize trip is a trip abroad. Let's say uh, uh, our our employees will have access, and the employees of say Cebu Pacific will also have access to the information, and for the purpose of disseminating our prize to you. And of course, promise not to use it for any other reason other than the reason you specified. And if the need arises, you must obtain consent before doing so. So you will only use the information, name, address, age, only to disseminate the prize, and for no other reason, you're not going to share it with anyone else. You cannot share it with anyone else. You cannot use it to send them promotional material unless you specify that. You cannot send them, you cannot share it with another client or another business partner without first telling them. Even if you need it for your business, no, you can't do that unless you first obtain their consent. So here, best to specify it here if you already have plans in the future. And then you also have to specify to inform the data subject of the right for access to be informed, the right to destroy, and the right to correct. So these are the rights of the data subject. So you just tell them you have the right to access your information, to be informed of what happens to it, the right to request destruction if you want it destroyed, and the right to correction in case the information is wrong. And then a way to exercise these rights. So basically, maybe you just provide an email at the end. Um, if you have any questions or want to exercise your rights, please email us at contact us at um, founder or startup.com. So, ayun. So you specify what kind of information you're collecting. You specify what you're going to use it for, who will have access to it. You specify that you're not going to use it for any other reason other than what you said, and require you will obtain their consent before doing so for using it for any other reason, and inform them of their right to access, be informed, destroy, and correct, and provide a way to exercise these rights. So I that's actually the end of our ano no, the my talk on legal matters. So we brushed up on incorporation, contract principles, and investments. Typically, more specifically on investors coming in, how do we handle contracts with them, and data privacy matters. So if you guys have any questions, or we at the Q&A portion, you can ask us any questions, no? Also, this is our website, Ren. If you want to schedule a consultation or further questions and answers, you can schedule a consultation with us here at calendly.com startup law. So if you have any questions, feel free to ask them. Thank you.
All right. Thank you so much, Attorney Luigi, for that intensive discussion on legal matters. So, founders, you may now raise your questions.
Sige, Hannah. If no one has any questions, it's almost lunchtime na rin. Maybe everyone's hungry rin. If there are no questions naman, you can just refer to this website, calendly.com, startuplaw.ph. If you have any further questions that you can't think of now or would like to ask later on na lang, you can just ask them here. So um, I think I can speak for all of us now. We'd like to go to lunch. Ay, sorry. Mary, you have a question.
Yes, sir. Here on the chat, I'm Sir Van ask comment a question. So please guide us
Ay,
how
here,
to
here. Sorry.
navigate start up from solo to 3 to 5 member team founding, starting very lean or bootstrapping founded and seeking VC funds slash government grants funding. How they split founders' ownership equity when VC putting money in the company from seed to series fund.
Ah, Well, for this one, no, this is not a super legal question, although um, we briefly touched upon this kanina. When you have government seeking government grant funds, of course you want to have a company, no? You want to incorporate to look more legitimate. uh, you how you split the founder's ownership equity. That's a question a lot of people always ask. It's always how you value, no, value when you're splitting between the founders, how much you value each person's contribution to the company. If it's if it's not clear yet, especially at the start, how how to divide that. What people sometimes do is they make it if they do it via vesting. So after a couple of years, um, the only time you get the shares, no? So you're invested. You're the founder is incentivized to stay with this company and grow it. But there's no clear-cut answer how to split the founder ownership equity without knowing how much what each founder brings to the table, how much each founder is contributing to run the company. That's a conversation to have that you have to have with each of the founders to properly determine how much their contribution is valued. Although at the start maybe you can have it equal, and then later on that's when you can bring in the vesting. Okay, so after a year we have a better idea, and founder A does more than founder B, and founder C barely does anything. So to vest additional shares, um, founder A gets a bigger share later on, founder B gets an okay share, founder C gets nothing later on.
Okay, there's another one question from Jules
Okay,
from Pitt.
okay.
So
Important documents or agreements before starting a team. Okay. So I mentioned earlier yung shareholders agreement. I think what you're um what you're going at, Jules, is how to mitigate risks, no? Relationship risk later on when the founders, syempre at the start you can all be friends, and then later on when you're running the business, it becomes messy na, it becomes confusing. So I suggest you start with the shareholders agreement to show na this is how we divide this is how we divide the work. Um, sorry, this is how we divide the work. This is how um, this is how we, this is how we'll invest the funds. This is what you guys have to do. Um, this is what we expect from you. This is how our relationship is going to be governed in this startup, in this company. And then sometimes what what some of our clients sometimes do is we sometimes put a failure to contribute provision in the shareholders agreement. This is the most extreme, no? This is basically the nuclear option for against a shareholder. Na parang, sige, if you're not going to play ball, if you're not going to participate, and um, if you're not going to, if you're not going to do what is expected of you, we're going to buy out your shares. We're basically going to kick you out, buy out your shares at maybe par value or whatever discounted rate. And then um we can and then goodbye ka na lang. So sometimes it's a vote between all the founders have to get together. Maybe you need a vote of 4 out of 5 to kick someone out by failure to contribute. Of course, that's one option, but a shareholders agreement where you basically set down your expectations, your responsibilities, your how the company will be run. That is the perfect document here to mitigate risks for that are unexpected for startups. So I hope I answered your question, Jules. Sige, Miss Ivy, question regarding copyright of virtual assets. So currently you're using assets from Pinterest and Canva. What legal pitfalls should you look out for when deploying your product to avoid copyright violations? Is it okay to use these online assets if you are modifying them in some way when applied to your app's design? So, good question, Ivy. If you're using assets online, you have to make sure first that, for example, these assets are you look for example on Pinterest and Canva if the creators are actually offering it as for free use or a fair use rather, sorry, fair use to for other people. The the policy of the website, whether everything that's on there, sometimes there's stock photos, that people generally use and are al- are basically fair use for anyone to use. Um, you have to check in on that, check in on the creator, and check in on the website. The safest bet, I think, would be to check in with the creator because they're the ones who um get to the creator's really the one who gets to say no. But what legal pitfalls you should look out for to avoid deploying a product to avoid copyright violations? Well, number one, whatever images you use, make sure that you have the right to use them, that it's either fair use or that you've asked permission from the creator, or that you made them themselves. Because to go into your next question, is it okay to use these online assets? Um, if you don't have, if the website doesn't say outright that it's fair use or that anyone can use them, I would say no to be safe. Lalo na if it's creator submitted, I would say no because the general idea is that if I posted this online, it doesn't mean everyone can use it, no, unless I say so. So you have to ask permission from the creator first. That is the safest way. So if you want to mitigate your risks there, always ask for permission. And then even if you modify them, that is not like a get out of jail free card na. Oh yeah, yeah, we used your design first. But we used your design first, but look, I made it different. I made it a bit different. In intellectual property law, that's I forget the exact name, but I think it's a right of transformation, something like that. But basically, if you make if you start out with one piece of art and you want to convert it to something else or you want to tweak it, um, that's the right of the creator and the creator alone. If someone does that on their own, I mean, if it's for your personal use, okay, fine, pwede na. But if you're trying to monetize that, that might be a problem later on. So they might not appreciate you taking their original work and transforming it into something else and calling it your own. No? Always best, always safe to ask for permission first. Typical lawyer's fee for IP application. I actually worked for a while no for an IP firm before I was admitted to the bar. I think the typical fee back when I was doing that was for a trademark application would be 20,000 pesos for the trademark application, but I'm not sure what it is now. Um I There's also a resource online, I think for the IBP of Cebu, where they put in the typical fees. Let me see if I can Google it now lang. IBP Cebu schedule of fees. Um, Here. I will just get the link here. Um, it's a Facebook link from the IBP of Cebu. They have a schedule of attorneys' fees. If I'm not mistaken, there should be um for trademark application here, but off the top of my head, it's 20,000 pesos per trademark application.
Okay,
So,
attorney, I have a simple question lang po.
mhm,
Meron kasi kaming na-interact with a startup, previous
mhm,
startup, that they deployed a hardware on a certain barangay. So they don't have a MOA, but they have the acknowledgement that the startup put their hardware there.
mhm.
So, advisable po ba, attorney, that they really do the MOA, or is the acknowledgement um, letter and it is notarized, is okay na po ba yung ganyan when
Mm,
deploying a hardware?
deploying hardware in a barangay. I would always say always go with the MOA, no? Because yeah, acknowledgement that you you've deployed hardware in a barangay, acknowledgement na you're allowed to do that. Yeah, that's good. Maybe it might even say how much for how much or how much is payment terms. But then, you know, if everything goes well and there's no complications, okay, then the acknowledgement was okay. But what if there are? What if something goes wrong later on? What if it even goes wrong? You just have a simple misunderstanding as to how to how to carry out your business there. Um, what what what's going to happen there? Who's going to be followed? So that's why it's always important to have your contract, whether a MOA, memorandum of agreement, or whatever form beforehand. Always good to have it executed so that in case the worst case scenario happens and something goes wrong, you know exactly what your rights are. Um, you know how things will, you know, you know where everything will fall into place. Because um when it's not clear yet, when when it's not clear yet, when things are not clear, it's good when the business is good. But um when business is bad, you're going to wish that everything was cleared up first before doing it. So, ayun, I would always advise to get the MOA because an acknowledgement might be good today when things are okay, but if uh, just a little misunderstanding later on, you're going to wish you had the MOA.
Thank you, attorney.
All right. Any more pahabol na mga questions, founders, before we proceed to our photo op? Going once, going twice. Okay, so I think wala na silang katanungan, attorney. So thank you once again, attorney Chief,
Okay.
this session.
Um,
Yes, sir.
yeah. Yeah. If you have any questions, again, there's the Calendly, ano. Actually, if you'd like, I could send that here, no? Here. So here, it's in the chat. If you have any other follow-up questions, you can schedule a consultation for there.
All right. Thank you so much, attorney, for sharing that. And allow us to formally express our gratitude by presenting the certificate of appreciation. Wait, this is a